Welcome once again to Lehto's Law. Here's Steve Lehto.
Today we've got a big win for the Institute for Justice and for landowners and privacy rights. Devin and Ed are among the people who sent me the story from WCYB out of Tennessee. And this is a case we've talked about before, but this is an update which appears to end the story in Tennessee. Tennessee's Wildlife Agency will not appeal a historic ruling on warrantless searches. And Richard Sims and Jordan Karnbach wrote this, and this is a decision that will affect wildlife law enforcement in Tennessee forever, or at least until something else comes along and they fight about it in court. The Tennessee Wildlife Resources Agency has decided it will not appeal its most recent court loss regarding searches conducted under the open field doctrine, and they had the right to take that to the Tennessee Supreme Court, or at least they could ask, but they decided not to even try. The decision was announced by the Institute for Justice, and it means that Tennessee wildlife officers will no longer be allowed to access private lands unless they've got permission or a search warrant, which, by the way, is kind of how things ought to be, I think. Now, I'll admit, when I've done these stories in the past, I've had people contact me or tell me, you know, Steve, there are people out there who break the law, and this is just a way that law enforcement can catch them. Yes. And the Constitution says that for law enforcement to catch somebody legally, they got to do certain things. And so if they're going to go onto private property and, plant cameras, which is what they're accused of doing here, then perhaps they should get a warrant. I think more people would expect that than to say, oh, they can just run around on private property all they want, unannounced. And I'm surprised, by the way, that none of them have gotten hurt doing that. But that's another story altogether. In 2018, the two men here found hidden cameras on their West Tennessee property. They sued the TWRA for violating their rights under the state constitution. Up until then, TWRA wildlife enforcement officers had operated using the open fields doctrine, which of course is a U.S. Supreme Court case that goes back to 1924, where courts said, well, if you've got a house and, a garage and then a huge piece of property that's mainly fields, think of a farm, right? The court said, well, the open fields near your house don't get the same protection that the house does. Or the curtilage of your house, the area immediately surrounding the house, often attached to us, like your porch or an attached garage or your back patio kind of thing. And so they say, you need a warrant for those things. But you would need a warrant to inspect these fields or these huge tracts of land that are forested attached to somebody's property. And so apparently, since then, they've been going around just assuming that they've got a license to do this, and it has now come to an end. And of course, keep in mind that was 1924. And here we are a good number of years later. So in 1924, the U.S. Supreme Court held that the Fourth Amendment to the U.S. Constitution does not protect land beyond the home and its immediate surrounding area. The court reaffirmed the doctrine in 1984 when it held that property owners have no reasonable expectation of privacy on any land the court deems to be an open field. However, the Institute for Justice attorneys arguing on behalf of these two men said that the doctrine violates the Tennessee Constitution. Now, they're talking about the Tennessee Constitution. We've heard about this before, where there sounds like there's a case involving a constitutional violation. And you hear that somebody goes ahead and sues and wins, and you realize they did it under their state constitution. Because there are constitutions in America on certain issues where the state passed a constitution more restrictive than the U.S. Constitution. And so it might be that if they'd sued under the U.S. Constitution, they might have lost. But I don't know that that really matters here. Following the ruling, the attorneys for these two men said, I think the best way to describe what my clients feel is safe. Safe. They can go and find some solitude, and that was destroyed by not only finding government cameras on their land, spying on them, but by government officials coming on and roaming around. So in its news release about the case, the Institute for Justice said, with the state declining to appeal to the Tennessee Supreme Court, this victory over warrantless searches is cemented. Now, as you might guess, the people who work for the TWRA are not happy. Several of them are quoted in a written statement from the executive director. We respect the Attorney General's decision not to appeal the case. When TWRA was founded 75 years ago, nearly all big game species have been hunted to the brink of survival. It was hunters who came together to self-regulate and allow inspection of private property to prevent bad actors from stealing wildlife from their neighbors and the state. A spokesperson for the TWRA said in an email, "We're currently working with the Attorney General's office for further clarity on our rights to inspect hunters. The agency will have new policy and procedures in place by the opening of dove season in September. TWRA already has a landowner consent process implemented for game wardens to enter private property, and all wardens have received additional search warrant training." Now, there is a retired officer they spoke to who said, "I'm disappointed. But of course, I've been disappointed in the administration since before I retired. I know the officers have to abide by the directives they're given, but this is going to be detrimental to the wildlife. It will keep officers from working illegal baiting, deer spotlighting, and other wildlife cases. Of course, I've given my local wildlife officer permission to access my own land anytime he wants to." And by the way, that's the interesting part. I suspect a lot of people, if approached, would say, you know something? If you want to come onto my land during certain times of the year, go right ahead. Thank you for asking. But when you find somebody on your property and you didn't give them permission to be there and they run away when you come, now you're starting to wonder what's going on. And so, or you find trail cameras they left behind hidden. And of course, as you walk up to it, you're being filmed on your own property by someone else. And that is a problem. So one officer who's now retired said, "You couldn't print what I'd really like to say. What I worry about the most is the wildlife suffering because of this. This is going to make folks who are behind the gate more illegal. The main tool we had was the element of surprise. That's gone away. Now it will require even more help from the public." So in May, a Court of Appeals judge wrote that the TWRA's contention is a disturbing assertion of power on behalf of the government that stands contrary to the foundations of the search protections against arbitrary governmental intrusions in the American legal tradition. Meanwhile, one of the men said, "This final victory has been a long time coming. For too long, TWRA officers have treated my private land like public property. But in Tennessee, our land just means more. It's part of who we are. And to hear the court say that our land deserves protection from these warrantless intrusions makes me proud to be a Tennessean." And so there's a little bit more to it than that, but I got to salute the Institute for Justice because they said this case is just another major victory for them in their project on the Fourth Amendment. They've got a whole series of cases, and they're striving to protect one of the foundational property rights, that is the right to be secure from unreasonable searches and seizures. Later this year, the Pennsylvania Supreme Court will hear argument in a similar case from hunting clubs, which were subjected to similar searches and hidden cameras. Scott Bullock, who is the IJ president and general counsel, said property isn't private if the government can watch you whenever it wants. We're confident this victory is just the first and will become a series of wins, reinvigorating protections against warrantless searches. And so remember, there's two things that were in play in this case. The allegation was that these officers came onto the property without permission, didn't announce themselves, they just came on and would poke around. They would also leave behind trail cameras, which they would then come back later and retrieve. So even though they come on the property and leave, they still had a presence there the whole time with those cameras. And so if I was walking around my own property and I found a hidden camera, that would bother me. Now, I know you're going to say, "Steve, trail cameras aren't hidden." Well, it depends on how well they're mounted and where they're put. But they're not exactly obtrusive. They're not exactly, look at me, look at me. They often come camouflaged, and you can place them places where they're not going to be that obvious. But the point is that somebody comes onto your property, wandering around, puts a camera there, and leaves. And that camera records anything that walks in front of it, including you. And it's your property. And we talked about this before, and I think it's akin to the guy who found the tracker on his car that was placed there by the police. Now, interestingly, I believe the police had a warrant to do that. But the point is, he found this tracker on his car, and he's like, what's this? Who put this there? There's nothing on it to indicate who put it there. So he took it off. The police came by, and they're like, "Hey, dude, what happened to our tracker?" He's like, "Oh, that was yours? How was I supposed to know that?" And so anyways, the court later said, yeah, guess what? When he finds it and doesn't know whose it is, he can take it off his car. So I guess the question really is, I think hypothetically I would ask this. If you come upon a camera in the woods that you own, it's your property, do you have the right to take it down? Or are you required to leave it there? Because if you're required to leave it there, now you're like granting them property rights on your property. So I think it was a really, really weird situation, but apparently it's happening in a lot of places, and I think it's wrong. I think most people do think it's wrong. Now, I know some people, again, like I mentioned at the top, I've spoken to people who go, Steve, there are people who hunt illegally, poaching or whatever, and they can get away with it because the state's got millions of acres of hunting land, and the DNR officers or whatever you got in your state, TWRA, can't cover all of it. And I understand that. In fact, I've seen reality shows where they follow these guys around and show what they do on a daily basis. And you get the impression that they're running around stomping out fires at 1/10 the speed they could if they had more help. I understand that. But you've got to remember it's always a balance. It's always a balance between your rights and the powers of law enforcement. And so, especially without a warrant, putting a camera someplace to record what happens on a piece of property, to me, that's completely wrong. Now, don't get me wrong. If somebody got a tip and some kind of evidence that something bad was happening and a camera might catch it, well, then you go to court and you explain to a judge what you think is going on, why you think that, and see the judge will issue you a search warrant that allows you to place the camera. And the search warrant would say, officers have got the right to go onto the property, put this camera in a particular place in an attempt to catch the following things, and then retrieve it sometime later. If a judge signs off on that, I got no problem with that. But that's not what's happening here. So I got to salute the Institute for Justice. I've mentioned before. I've met Scott Bullock. I've met a lot of these attorneys. They're great people. They are doing this work. And if these guys, for instance, had wanted to chase this case on their own, it would have cost them a fortune. Institute for Justice is a nonprofit organization that lives entirely off the donations of generous people, such as my viewers, who have been supporting them in an amazing fashion since I started talking about them. And the reason I push them is because I think they do great work. This is not an ad. They're not sponsoring me, nothing like that. I just simply think they do great work. So I'll put a link to them in the description below the video. And their website is a wealth of stories just like this. So in other words, when I tell you go look at the website, I'm saying go there and read the stories. See the work they're doing. And if you want to, support them. But if you don't feel like supporting them, still bookmark their page and read the stuff they're doing. And you'll see that they're doing extremely important work. You can support them with just moral support. Check out their page and go, oh, check out this story, check out that story. And it might surprise you at the things that are still happening in this country. And one of the things, when I heard about this story, my first knee-jerk reaction was, that's wrong. That's wrong. And again, I know people who say, Steve, but hunters, yeah, you got to catch them using legal means. And in Tennessee now, that means that they can't go on your property without permission or a warrant. So thanks to everybody who sent to me, including Devin and Ed. WCYB out of Tennessee published this. Richard Sims and Jordan Karnbach wrote it. Tennessee's Wildlife Agency won't appeal historic ruling on warrantless searches. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. As you wish.